My name is Ben Hart. I am an American attorney here in Bangkok, Thailand. This video will briefly discuss the K1 visa, which is a fiancé visa, and how that visa operates for those seeking immigration benefits to the United States. The K1 Fiancee Visa grants the visa holder 90 days lawful presence in the USA for the specific purpose of marrying a United States citizen fiancé and thereafter filing for adjustment of status, aka permanent immigration benefits, lawful permanent residence, also known as a green card. One of the main stipulations of a K1 visa is that the foreign fiancé must be intending to marry a United States citizen fiancé. It cannot be another green card holder. It must be a U.S. citizen fiancé in the United States. It should also be noted that the couple must have met at least 2 years prior to the initial filing of the petition for the K1 visa. The K1 visa, the filing will occur with the Department of Homeland Security, where it will be adjudicated by the United States Citizenship and Immigration Service. Thereafter, and assuming approval, it will be sent to the National Visa Center under the auspices of the Department of State. The Department of State will then send that case on to the United States Embassy here in Bangkok. Once it arrives here in Bangkok, and we are assuming this case involves a Thai-American couple, once the case arrives here in Bangkok, the consular section of the U.S. Embassy here will give that case a case number, and the Thai fiancé will be informed of a need to go ahead and gather relevant documentation and undergo an interview process with the consular officials in order to ultimately be granted a visa to the USA. It should be noted that once a K1 visa is granted, the visa holder has 6 months to use the visa, and then once the visa is used and the K1 visa holder goes to the United States, once in the United States they have 90 days with which to get married to their American citizen fiancé and then file for adjustment of status. A couple of things should be noted. Should the couple opt not to get married while in the United States on a K1 visa, so long as the K1 visa holder returns to either Thailand or, frankly, just leaves the United States within the 90-day period, no harm, no foul. There is not an overstay violation garnered against that person. Something else that should be noted. K1 visas can only be used for the specific purpose of marrying the American citizen fiancé listed on the visa petition. So a K1 visa cannot be granted for the purpose of traveling to the United States to marry one person, and then that traveler to the United States, that immigrant, cannot then turn around and marry someone else for whom that K1 was not petitioned for. Another thing to note, the adjustment of status process, that is the process by which someone entering the United States is granted immigrant visa benefits, i.e. green card status. Should be noted that going into the United States on a K1 visa, the K1 is technically a non-immigrant visa, although for all practical purposes it is treated as an immigrant visa because it has a dual intent component to it, whereby the person traveling in the United States has the intention to remain in the United States, although their current visa, namely the K1, is not issued for any longer length of time than the 90 days permitted under the law. Many people often ask me, why 90 days? It seems like an arbitrary number. In point of fact, I would say it is a rather arbitrary number, but 90 days was the amount of time deemed reasonable by the drafters of the Immigration and Nationality Act, who felt that 90 days was enough for a couple to go to the United States, determine if they wanted to be married, and adjust status to lawful permanent residence in the USA. A point of fact about a couple of things. It should be noted that presently it is a possibility to live, to use K1 visa for same-sex couples, thanks to recent Supreme Court decisions and subsequent policy changes by the various regulators who oversee immigration policy. It is now possible for same-sex couples to utilize these same benefits as different sex couples. One final note, it should be noted that at least here in Thailand, there are quite a number of outfits, operations, whatever you want to call them, who claim to have proper qualifications to assist in immigration matters. It should be noted that pursuant to United States Federal Code, only licensed attorneys are permitted to charge a fee in association with the K1 visa process. And also, frankly, they're really the only ones qualified to assist. Those claiming to be able to assist one in the K1 visa process who cannot provide some qualification in the form of a bar card or some form of proof of having been admitted to the Bar Association or the highest court in one of the jurisdictions of the United States, I would strongly caution people looking for assistance in these matters to possibly look for someone who can prove their qualifications pursuant to United States law. Thank you.